Hello everyone. Am I audible, loud, clear? I can see 9 people in the video. Please respond, guys. Come on. I need some voice. Good evening, George. Nice to see you. Good evening, Malika. So, Mahima, this side, I think most of the students there know me. They have been interacting with me before or now and then. So, how are you guys? How's the preparation going? If you guys are preparing for DJs, or even if you're not preparing for DJs, then how is the preparation going? Come on, tell me in the comment box before I share my screen and get the things ready, and then we'll start the quiz. Very hectic. Okay, Shaktija. I understand it might be very hectic for you because MP is also out and Delhi is also out and I think Haryana will also be out, Rajasthan will also be out. So we have a lot of seats coming up. But all the students here, especially I know some of them, they can do really well. So, how many of you have prepared for CRPC today? Come on, reply yes or no. How many you have prepared for CRPC today? Today we are going to have a quiz on the first part. For the first part of CRPC, which is going to be till section 327. So we are going to have quiz only till section 327 today, and tomorrow I know it's India versus, I think it is, which team is it? Australia. Come on, tell me which team is in the finals. Tomorrow is the final match, I know, and India is in the finals. This is all I know. So I know most of you will be distracted, but we have to be there. We have to attend the quiz, do the rapid revision sessions, and study the later part of the CRPC. So, shall we begin with the quiz? Guys, come on. Nobody answered that India is against which team. Nobody is watching the match. Is it so? We have very less time, but I'm still asking which team is against India. Come on, guys, comment. I think Australia is it? Okay. I think only few of the students are watching match these days because all of us are very busy preparing. Along with me, I was busy preparing this for you guys. So let's begin. Come on. The very first question on your screen, and the rules I think you all know because you have been attending the quizzes before. You have to mention the correct option. If the options are in the form of numbers 1 2 3 4, then the correct number in the comment box, or if it is in the form of A B C D, then correct is it A, B, or C, or D in the comment box. Okay, so let's begin the first question. Okay, George is not interested in cricket. I think he's interested in CRPC. So let's begin the quiz. And the first question is, which of the following statements is wrong? Option number 1 is, oath may be administered to an accused before his examination under section 313 CRPC. Accused can refuse to answer any question when he is examined under section 313 CRPC. Accused can be put to any question by the court at any stage of the trial. Evidence which incriminates the accused has to be put to him or her by the court. I'm giving you 10 I'm giving you the first 5 seconds to answer because the question was already read. Okay, so the correct answer is option number 1. Since I asked that which option is not correct, Oath is not necessary under section 313, and the reason is very simple, that section 313 is the last resort for an accused, right? If the oath will be administered, he'll never say the truth and he'll be bound by it. So that is the fact that why the provision of oath is not included under section 313 clause 2. Okay, most of you are answering right. Very good. Medha, Pritika, Indu, Anikwa, Shaktija, Seema. Very good. Most of you are confused with option number 4, but it is option number 1. So every time you have such options which confuses the students, you need to eliminate and you need to choose the most appropriate one, which is option number 1. That is the reason behind that is the Bare Act language, which clearly mentions that no oath has to be administered. Okay. Question number 2 is, if the person, after executing a bond for his appearance in court, fails to appear, then under which section the court may issue warrant of arrest against that person? Is it 89, 87, 204, or 44? And the time starts. This is your ghadial and it starts now and it ended. Come on, guys. Yes, it is option number 1 again. There's a difference between section 87 and 89. 89 is for the breach of a bond, while 87 is when the warrant can be issued in lieu of summons. So it is option number 1. It was slight confusing between 87 and 89. Everyone answered right, almost. Shaktija, Indu, George, very good. Akash, Malika, Nikwa, very good. Answer with 1, 2, 3, 4 because we are having the options as 1, 2, 3, 4 so that the clarity remains. Next question is, who becomes essential while implementing the policy of separation of judiciary from the executive? Come on, guys, this is a very easy question. Judicial magistrate of first class, second class, executive magistrate, or a metropolitan magistrate. And the time starts now. Come on, this was a general question. Nobody answered. Okay, only George answered yes. This is option number 3. This was somewhere relating to constitution also. You guys had the constitution quiz on the very first day with the rapid revision session also. This is executive magistrate always. Article 50 of the Indian Constitution also empowers the state government, and executive magistrate is a government authority. So indirectly you could have related this with constitution also. Come on, this is a केस लॉ क्वेश्चन. ये आता है तो आता है, नहीं आता है तो नहीं आता है. So try to answer this. In which case the Supreme Court held that the state is under a constitutional mandate to provide free legal aid to an indigent accused person? Hussain Ara Khatun versus State of Bihar, D.K. Basu versus State of West Bengal, State of Bihar versus Kapil Singh, Khatri versus State of Bihar. And the 5 seconds are, everyone is answering wrong here. This is where I have put such question. Everyone has answered wrong here. The correct answer is Khatri versus State of Bihar. Yes, Hussain Ara Khatun talked about free legal aid, but it did not held that state is under a constitutional mandate to provide free legal aid to a poor accused person. I hope everyone is aware about who is an indigent accused person. It is defined under CPC. So this was held under Khatri versus State of Bihar, and this is why this is a quiz relating to DJS exam, because this will confuse you with the options. So yes, pauper it is. Yes. So only few of you answered right. Very good, Runa, Kanika, Tamanna. Very good. Let's move ahead with the next question. This is a heavy one. Let me read it very slowly for you, and you guys also read it with me. The defendant husband agrees to pay rupees 400 per month to his plaintiff wife in consideration of her giving up prosecution against him under section 494 IPC, an offense compoundable with the leave of the court. With the leave of the court, the offense was compounded and the husband was acquitted. In an action by the wife to enforce the agreement, The husband contends that the agreement is one to stifle prosecution, that means to stop the prosecution, and hence unlawful. In the light of the above situation, which one of the following is correct? One is the agreement is one of stifle prosecution, and hence the husband's contention will prevail. It is against public policy to give up prosecution in a criminal case by receiving consideration for it, and so the wife cannot enforce the agreement against the husband. The wife can enforce the agreement, okay, against the husband because because this is supported by agreement consideration. The wife can enforce the agreement against the husband. Agreement is not for stifling prosecution, as the offense is one compoundable with the permission of the court and has been so compounded. I wasn't expecting this. Still, I'm giving 5 seconds to the people who are not answering. I'm really impressed. So the correct answer is option number four. Yes, this is a very easy question, but a lengthy one. So this gets your time, and this is a very, this type of questions are very common in Delhi. So read the questions carefully as you did Abhi, and you'll be able to answer. So the correct option is option number four, because if it is compoundable with the, can someone tell me with what is section 494 IPC? Come on. Very good, Raju, Anikwa, Komal, Muskan, Medha. Very good. Shaktija, George. George was the first that made me smile to answer it correctly. Very good, George. Yes, it is bigamy. So, bigamy is the offense which can be compounded with the permission of the court, and it was compounded. So, the agreement is obviously not for stifling the prosecution, and it can be enforced. It was very simple if you read the question carefully. Okay, does CRPC apply to the proceedings of contempt of court? Yes, no, can't say, none of the above. And the time starts now. Come on. Nobody answered. No, it does not apply on contempt of court. Only Shaktija, Medha, Akash, Seema answered correctly. Contempt of court has a separate act and the separate procedure altogether, which is the jurisdiction is also excluded under 4 clause 2 and 5. So contempt of court CRPC does not apply. So the next question is FIR a substantive evidence? Yes, no, can't stay, depend upon the circumstances. Come on. Okay. Okay. Yes, everyone answered right. Very good. Very good. Raju, please answer with the correct option. It would be easier for me to see. Yes, Chanchal, right, but answer with the correct option. Everyone is right. It is not a substantive evidence, and it is used to corroborate and contradict under 157 and 145 of Indian Evidence Act, respectively. It cannot be used as a, even to refresh memories. It can be used under Indian Evidence Act, but cannot be used as a substantive evidence. Again, a case law, under which case the Supreme Court has entitled the accused person to remain silent during the examination by the police under Section 161, Clause 2, if his answer sought has a reasonable prospect of exposing him to guilt in some other accusation, actual or imminent, even though the investigation underway is not with reference to that. Nandini Satpathy versus PL Dani, Gyan Singh versus State, Ram Jethmalani versus CBI, Khatri versus State of Bihar. Come on, guys, this is very easy. Yes. Okay. Very good, everyone. Yes, this is a very landmark case of Nandini Satpathy. This case talks about rights to remain silent under Section 161, Clause 2. Can somebody tell me, and it is also related to Article 20, Clause 3, obviously, can somebody tell me what is Section 167 in the comment box? Till the time I read the next question, which is again a very easy one. I'm waiting for the comments. How many same kind of offenses can be charged together in a joint trial under the purview of Section 219? 2453. You have two questions to answer. What is section 161 of CRPC? Can somebody tell me? Examination of witnesses by police. Recording of statement of witness. Okay. Yes. So this question, the time has started, and the correct answer is option number 4, as everyone answered right. Under section 219, it is very clearly mentioned that the number of offenses should be 3, and the time period is 12 months. Okay? Of the same kind. And I hope the same kind definition is clear. On which of the following ground the court shall cancel the order of maintenance? Wife is living in adultery without any sufficient reason. She refuses to live with husband, living separately by mutual consent. All of the above. The time has already started. Come on, guys. Yes, the correct answer is option number 4. It is section 125, clause 5, where the cancellation is provided where all the grounds are mentioned, which are mentioned in the question. Let's move ahead with the next question. Come on. Are we on the same page? We have 19 people. I can only see few of you replying. I'm going to take the names who are replying: George, Shaktija, Raju, Runa, Bhavika, Seema, Kumud, Pritika. All the other, I think, 7, 8 people should reply to the questions. Are we on the same page? Yes. Do not open the Bare Acts, guys. This is the time before the examination, and you have to answer it by seeing from the screen. Okay, let's move with the next question. Under section 320 of CRPC, who can compound an offense on the behalf of a minor? Legal representatives, legal representatives with the permission of the court, person competent to contract on his behalf, person competent to contract on his behalf with the permission of the court. No, it is option number 3. Please read the Bare Act carefully. Okay, let's move with the next question. In which of the following case the Supreme Court held that a daughter who attained the age of majority, not suffering from any physical or mental abnormality, and is still unmarried, is not entitled to claim maintenance from her father under section 125? Abhilasha versus Prakash and others, Jagdish Jugawat versus Manjulata, Fatima Shirin versus State of Kerala, none of the above. This is also one of the landmark cases. Difference of opinion here. And the correct answer is option 1. Good job, Pritika. Only you were able to answer it. Everyone was answering option number 3. Good job. It is Abhilasha versus Prakash and others. Which of the following is or are correct with regard to section 127 of the Code of Criminal Procedure? The magistrate can increase the monthly allowance for maintenance. Magistrate can decrease the monthly allowance for maintenance. The magistrate can cancel the order of maintenance, or all of the above. Yes, this was an easy question. All of you are answering it right. Yes, the correct answer is option number 4. Section 127, 1, 2, and 3, all the 3 clauses mention that these 3 things, that the magistrate has power to cancellation of the order of maintenance, although is under section 125, clause 5 also, but alteration in the form of increasing or decreasing is in the under section 127. Next question is, which of the following sections of the CRPC prohibits a male police officer from touching the person of a woman while making her arrest? 41 clause 1, 42 clause 2, 46 clause 1, none of the above. None of the above. Okay, the previous question answers. And the time is over. Yes, correct. Very good, Pritika and Shaktija, Komal, Medha. You guys are reading the Bear Acts very nicely. Komal, Aneja, Shivani Sengar, Akash, Raju, Anikwa. Very good. Yes, this is proviso to section 46, clause 1, which prohibits a male officer from touching the person of a woman while making her arrest. After investigation pertaining to an offense of murder, the police files a cancellation report. The report can only be accepted by the magistrate, the court of session, the high court, none of the above. This is a minute one, not a tricky one, but a minute one. Somebody who would have read the Bear Act very nicely would be able to answer only. Is it? Yes. I'm really impressed with Pritika's preparation. Touch wood, but yes, it is the magistrate. This is mentioned under section 169. Malika also. Very good. George also. You guys are on fire completely. Police remand of an accused cannot exceed 7 days, 9 days, 12 days, 15 days. Police remand. Police remand. Okay? Mind it. Yes, it is on question option number 4. Because police remand, the highest number of days is 15 days under the police remand, which is clearly mentioned under Section 167, Clause 2. The subclauses of Section 167, Clause 2 clearly mentions it. And this is a very important and a landmark section. Yes, generally 14 plus 1 is the rule, but whenever such question comes, you have to mark 15. This is from one of the past years only, so you have to mark 15 whenever such a question comes. Generally, the rule is 14 plus 1. Correct, George. Okay. Considering the following statements, bailable offense within the meaning of Criminal Procedure Code means an offense which is enumerated as bailable in the first schedule, an offense which is made bailable by any other law for the time being in force, all other offenses as stated in criminal law. Correct. See the options, find the coding, and give your answer. I'm not changing the screen because this is a coding question. Nobody answered. No, it is 1 and 2. Okay, why everyone is answering 1 and 3? All other offenses as stated in criminal law, nahi. An offense which is made bailable by any other law for the time being in force is also bailable. If you'll read the section carefully, you will see this line. Can't see the options. Can anyone others also tell me why you guys cannot see the options? Now, okay. Okay. Okay, let me just change the layout then. Now, huh. It is visible now. Yes, now everyone please answer. Now which one is the correct option here? I'm asking the correct codes here. I'm giving you yes, correct, correct. It is 3. Okay. An accused is entitled to statutory bail. Please let me know if the now I have improved the frame. I think the questions will be visible, right? Yes, 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 correct. Third was the correct answer. An accused is entitled to statutory bail, default bail, if the police fail to file the charge sheet within how many days of his arrest for the offense punishable with imprisonment up to 10 years. Up to 10 years. 30, 60, 90, 180. I'm still giving 5 seconds for everyone else to answer. Okay, it was up to 10 years. Up to 10 years, guys. Not more than 10 years. It is 60 days, not 90 days. That is what made me laugh. And this is a DJS 2019 question. Come on, guys, please at least solve the past year papers. It is option number two. Okay. Any police officer, please read the question carefully. Any police officer may not, without an order from magistrate and without a warrant, arrest any person who has been concerned in any non-cognizable offense, who has been accused of committing a non-cognizable offense, refuses to give his name and address, who has been a released convict, or who has been accused of housebreaking. Yes, correct, Malika. इसलिए ऐसे questions दिए हैं. Okay, again difference of opinion थोड़ा सा. The 5 seconds have started. The correct answer is option number one here. Very good, everyone. Very good. Shaktija, George. In George is very smart. First he wrote option number two and then okay, option number two शायद पिछले question के लिए उसने लिखा. So the correct answer is option number one here. Yes. There are 9 grounds where police may arrest without obtaining notice from magistrate and without warrant. Out of those 9 grounds, these are the sum of the grounds, and the only one ground which is suitable here is only option number one for the non-cognizable offense. FIR is not a substantive evidence. It can be used during trial. Come on, to contradict the informant, to corroborate the informant, both A and B, neither A nor B. जिन्होंने पहले से first minute से join किया हुआ है session, those persons will be able to answer, and I need all of you to write the sections also. इसके बाद evidence भी है, because which sections of evidence allow to contradict and to corroborate, क्योंकि सबने सही आंसर दिया है except few. George, come on. To contradict or to corroborate, both A and B. Why is everyone answering option number two? Yes, 145 and 157, correct. So the correct answer is option number three here and not two. Again, this was a previous year question, and you need to remember 145 and 156, 157, always of the Indian Evidence Act. Yes. Next question. It is again a heavy question. Read it carefully. If a French national on a tourist visa to India was raped by a group of 4 boys 2 days prior to her scheduled departure from India. FIR was registered on a statement, and the offenders were charge sheeted. On being summoned by the court to depose as a witness during trial, she refused to come to India on the ground of fear and inconvenience. Which one of the following is the most appropriate for the trial court? Issue non-bailable warrants against F through Ministry of Home Minister to compel appearance, initiate proceedings for punishment for non-attendance by F under Section 350, drop F as a witness and acquit the accused persons, issue a commission for examination of F. Very good. I am really impressed. Yes. The correct answer is option number D here. This is under section 189, which allows the court to issue commission in such a cases. In the cases of a foreign national, always a commission is issued. And section 189 is a very important section because the sections dealing with foreign nationals and the foreign countries automatically becomes important for all the states, and especially the people who are preparing for Delhi, Haryana, and Uttarakhand. These states are prone to ask such sections. The next question is a confessional statement recorded in all with special procedure under section 164 CRPC can't be used as a substantive evidence at all, can't be used as substantive evidence without being formally proved, can't be used as a substantive evidence without being formally proved, can be used, sorry, either A or B. Yes. It is also one of the previous year questions from 2016. Yes, the correct option is option number 3. It can be used as a substantive evidence without being formally proved, and it is under section 164. So let's move ahead with the next question. A person accused of an offense before a criminal court can be called upon to give evidence on oath upon a request in writing from the public prosecutor, by an application made by the complainant, by a director of the court, by the accused on his own request in writing. I need the section number also here because this is a very important section. With the correct answer, I need the section number also. The correct answer is option number 4, and the relevant section is 315, which prescribes that accused person to be a competent witness. Yes, the correct answer is very good, Kanika. Option number 4. Let's move ahead with the next question then. Section 306 of CRPC provides that magistrate inquiring or trying the offence at any stage of the inquiry of or trial may tender a pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relating to the offence. Pardon may be tendered to an accomplice under section 306 CRPC when he is not in a position to stand trial due to infirm health, when he is declared insane. He undertakes to make full and true disclosure of the facts relating to the offense, all of the above. Very good, guys. Yes, that was section 315. The correct answer is option number 4 here. All of the above. Pardon may be tendered. No such condition is required to tender pardon, even if he is whatsoever. The court will tender pardon if the conditions are fulfilled, mentioned under section 306. Yes, very good, Maya. Runa, very good. The correct answer was option number Seema, very good. Every police officer on making arrest has to forthwith give information regarding such arrest and the place from where the person was arrested to the magistrate of the area, to the complainant or the victim, to the friend, relative, or such other person disclosed or nominated by the arrested person. It is not necessary to inform anyone, but the person arrested must be informed about the grounds of arrest. The time has started. Yes. The correct answer is option number 3. Very, very good. Very good, guys. Everyone answered it correctly. Everyone. We have 22 people and only few people are answering. Please, guys, come on. Everyone, I want everyone to answer. The correct answer is option number 3 here. Section 50 clause A cast clause 1. 50A clause 1 prescribes the same. And this is also one of the previous year questions. The proceedings in a case shall be in camera. Cases relating to section 376 IPC, maintenance cases, testamentary and intestable succession cases, all of the above. I need the section number also here. The proceedings in a case shall be in camera. Which section says that the courts to be open, and which section's proviso says that the proceedings shall be in camera of which cases? Yes, absolutely right. Pritika, Indu, Seema, Shikha, Medha, very good, very good. Yes, it is option number 1 and section 327, the last section of the very important chapter of for the point of you of from the point of view of prelims, which is from section 300 to 327. It is 327, which says courts to be open, and for section 376, which is offense of rape, the proceedings has to be in camera. George, this is 327. Runa, this is 327, not 307 or 151. Where an investigation can't be completed within 24 hours, depending upon the facts and circumstances of each case, magistrate can order a person to remain in custody for 15 days, 16 days, 1 day, all of the above. Again, thoda sa twisted. Yes. The correct answer is option number four. Because all of the, see, the custody is not mentioned here. Which custody I'm talking about? The question is talking about either of the custodies. It can be police or the judicial. So the judicial custody, the limit is 90 days, 60 days in some of the cases where up to 10 years imprisonment is prescribed. So it can be either 1 day, 15 days, or 16 days. That is why the correct answer is option number four. And this is also one of the questions from, I think this was from Haryana, not DJS, but the pattern is same. A metropolitan magistrate may pass a sentence up to 3 years, 5 years, 7 years, none of the above. Police custody up to 14 plus 1, George. But the custody name was not mentioned there. That is why it confused. Correct. Everyone is right here. Section 29 prescribes the limits of sentences of various kinds of magistrates, how many years of imprisonment and fine they can provide. This is a very potential question in all the prelims exams. So yeah, yes, the metropolitan magistrate can pass a sentence of 3 years. Many of you are answering three. I can understand you are trying to say it as 3 years. 7 years is CJM. Metropolitan magistrate is 3 years. A magistrate may take cognizance of an imprisonment for a year but not exceeding 3 years offence. On police report, on private complaint, suo moto, all of the above. Again, a twisted one. Yes, very good. Section 190. This was a very, very easy question if you would have been able to figure it out. The magistrate can take cognizance irrespective of the number of years offense of punishment on police report, on private complaint, and suo moto, very clearly mentioned under section 190. A person having sufficient means rejecting to maintain his parents is liable to maintain the parents, arrest, forfeiture of his property, all of the above. Come on, guys. Yes, this is also a DJS 2007 question. Correct answer is option number four. It is mentioned under section 125, clause 3 that the accused, the person rejecting to maintain his parents, can be asked either to maintain the parents or can be arrested, or his property can also be forfeited. Next question is, duty of a person making arrest includes giving information regarding the arrest and place of detention of to any of his friends, relatives, or nominees, informing the person of his arrest as soon as he is brought to the police station, an entry of the fact as to who is the person informed in a book kept in police station for this purpose, all of the above. Yes, the correct answer is option number four. This was a very direct question. Yes, very good, George. This is DK Basu guidelines, exactly stated. This is DK Basu guidelines and also mentioned under section 41, clause B. A person arrested should be presented before a magistrate, excluding time for journey to the court within 24 hours, 48 hours, 72 hours, none of the above. Come on, guys. I need section also. Many of the sections under CRPC states this, but 167 is the first section which comes in our mind. Once I remember when I was preparing, I made a list in from CRPC just to remember the sections, that which all section talks about 24 hours provision, and which all sections mention good faith in the language of the Bear Act. Many of the sections talk about good faith. So in IPC, so I used to make such lists to remember the sections. Yes, very good, Divya. 57, 76, 167. Yes. Which is true about recording a confession by a magistrate. A police officer should be present so that the accused may not flee. The magistrate should warn that it is not necessary for the accused to confess. Prior to confession, he should be left in police custody for some time, or all of the above. True, true. Correct. Yes, it is option number two. Very good, Kanika, George, Shivani, Seema, Akash, Medha. Medha, you have been गायब हो गए थे आप. थोड़ी देर रुको, प्लीज. 8:30 तक रुको. You need to give the exam and clear this time. I've mentioned it पहले भी बहुत बार. Stay here with me, Medha. So the correct answer is option number 2. 164 clause 2 mentioned this, that the magistrate should warn that it is not necessary for the accused to confess. And again, this is relevant with constitution also. A court may issue a search warrant where such document is not known to the court to be in possession of any person, where the court considers that the purpose of any inquiry, trial, or other proceeding will be served by general search or inspection, where the court has reason to believe that a person upon requisition will not or would not produce the document or a thing, all of the above. Okay. देख देख के मत करो आंसर यार, सब सब फिर एक एक जैसा आंसर कर रहे हो. Do not copy these people. You are not going to be in the group. Okay, everyone, almost everyone answered it right. Yes, this is option number 4, section 93, when search warrant may be issued. Next question is, in a plea bargaining, who may participate? Police officer investigating the case, victim, accused, or all of the above? Yes, it is all of the above. Very good, guys. You guys are able to answer the direct questions very easily. So from now, focus on the indirect questions, the trickier one. This is what I can see from the performance of all the 33 people. Oh, we have 33 people and only 10 people are answering. Anjana is the new one. Hi, Anjana. Yes, the correct answer is option number 4. All the other students are also right. So the next question is, a plea bargaining can't be effected in which of the cases? Where the offense is punishable with imprisonment exceeding 7 years, where the offense is against a woman, where the offense is against a child below 14 years, or all of the above? Yes, it is all of the above. It is section 265B, application for plea bargaining, and all the mentioned persons and all the mentioned like the condition mentioned here, plea bargaining, we cannot enforce the plea bargaining in all the mentioned cases. Next question is, if any court has reason to believe that a person against whom a warrant is issued is absconding or concealing himself, the court may issue a proclamation. The person mentioned should be accused, witness, any person, or any of the above. Yes, it is option number 4. Very good, Nishant. Okay, hi Nishant. Stay with us now. Answer all the questions. You are answering the correct answers. So this is option number 4, which is specified under section 82. The next question is, An offense punishable with the punishment exceeding 2 years is triable as summons case, warrants case, both, either A or B. Yes, the correct answer is option number two. Good George, good Kanika, Medha, Malika, Indu, Anika. Okay, ये इतना easy question था. All of you are answering this. So this is under section 2X, which defines the warrant cases, and all the other cases are called summon cases. Come on, write the relevant section and the clause of summons case. 2X define warrant case, then which section defines summons case? Write it in the comment box till the time I read the next question. Whether an offense is compoundable or not is provided under which provision of CRPCU? Schedule 1, Schedule 2, either A, B, or C, none of the above. Very good. And you know the trick, right? W, X. So this is ulta करके याद करना है. Yes, all of you are answering this very right. जैसे ही direct questions आए, the list of direct questions I have put, all of you guys are answering. This is DJs guys. ऐसे बहुत कम questions होंगे. So yes, the correct answer is schedule 1 here, 3. And the next question is, if an accused before a sessions court can't engage a pleader, the court shall refer him to state legal service authority, engage a pleader for him at state expenses, proceed with the matter without counsel for the accused, none of the above. It is option number 2. Very good, Medha. Very good. Shrishti, Tamanna, very good. Engage a pleader for him at state expenses. Obviously, guys, read section 304 and you will get the actual correction. Okay, now we have some mark true and false questions. This was a trend where DJs followed these kinds of questions, so you never know. The central government can appoint one or more public prosecutor for any case or class of cases in any district or local area. True or false? One or two? Yes. Section 24, Clause 2 mention this, that they can appoint a public prosecutor. A person who has been in practice as an advocate for not less than 7 years can be appointed as a special prosecutor. True or false? Read the question again, guys. True or false? Special prosecutor. Yes. घूम गए घूम गए सब घूम गए सब घूम गए शक्तिजा आप पूरे घूम गए. This is false because special prosecutor I'm talking about, not the public prosecutor. For public prosecutor, we need 7 years. For special public prosecutor, we need 10 years. Okay. A criminal court may, in case of police diaries, inquire and use such diaries both as evidence and to aid it in the trial. Use such diaries not as evidence but to aid it in such inquiry or trial. Not use it either for evidence or for aiding it in the trial. Send for the police diaries of a case under trial but not under inquiry and use such diaries as evidence. Very easy but lengthy. Very good. Very good, Seema. Sandeep. Yes, this is mentioned under section 172 that it can be used, we can use such diaries not as evidence, but just to aid for inquiry and trial. A woman can claim maintenance under section 125 CRPC only if she is the wife of a Christian or Hindu and not if she is a Muslim. If she is the only wife of any Indian male, if she is a wife of any Indian male, only if she is the lawfully wedded wife of a Hindu. Very good. Very few of you answered it right. I'm really impressed, George. Very good. I'm really impressed. You are not appearing, but you are on fire today. Not today, I have been hearing that you are on fire. You were on fire in the previous quizzes also. If she's the only wife of any Indian male, guys, bigamy mein we cannot give maintenance. Okay. In a summary trial, the maximum sentence of imprisonment that can be awarded on conviction is 1 month, 3 months, 2 years, 6 months. Yes, 125 is secular. Summary trial. Why 4? ये CPC में कहाँ पहुंच गए मल्लिका? Summary suit, summary trial. Okay. Don't go. अच्छा, okay. Don't jump on CPC, guys. The correct answer is option number 2. 6 months उधर CPC से relevant है. This is 3 months here. Okay. This is section 262, and I am going to raise this question in one of the subsequent questions also. Remember, like, make me remind that I have mentioned this in the summary trial wala question. In a case instituted on a police report, the criminal court shall, when dealing with an application for plea bargaining, ensure notice to and the participation of investigating officer, public prosecutor, victim and accused, public prosecutor, victim and accused, investigating officer, victim and accused, only the public prosecutor and the accused. Guys, this needs very minute reading of the Bear Act. Yes, this is where the difference of opinion comes. Okay, the correct answer is one, Pritika. This is the correct answer is one here. Pritika was shining before, but read this section carefully, Kritika, 265C, and especially the sections, the provisions which are amended, the chapters which are amended automatically becomes very important. So yes, it is option number 1. Section 133 of CRPC concerns with the conducting of inquest by executive magistrate into unnatural death of any person, the powers of district magistrate or an executive magistrate to conduct inquiry and make a conditional order for removing any unlawful obstruction or nuisance in public place, search by a public officer, the procedure to be followed by executive magistrate upon being satisfied that a dispute concerning land or water is likely to result in such breach. कोई बात नहीं प्रतिका, उधर मार्क करके मत आना, छोड़ आना, नेगेटिव मार्किंग है दिल्ली में. इधर you can treat it like MP. Okay, again difference of opinion. This is why difference of opinion in this question. This is very direct. Why people are answering search by police officer? 133 is conditional order by executive magistrate and the district magistrate. These sections are relating to removal of nuisance. Whenever such a question comes relating to nuisance, remember that this is under these sections only: 133, 144, 144A, B, AA. These sections are very important. And the authorities of executive magistrates, subdivisional magistrates are relevant under this particular chapter. Yes, it is 2. Yes. Okay, let's move ahead with the next question. Break चाहिए? Because I can see थोड़े heavy questions आए हैं अभी. थोड़ा घूम गए हो तुम लोग. Break चाहिए? Guys, come on, answer. ठीक है, but DJS में break नहीं मिलेगा. So let's move ahead with the next question. I'm going to give the break after a while. थोड़े से heavy questions हैं अभी आगे. The woman has alleged facts that constitute the offense of use of criminal force with intent to disrobe disrobe, punishable under section 354B of IPC. The failure to record information about such an offense is an offense under section 166A of IPC, which is a cognizable offense. Okay. A woman approaches X, an officer in charge of a police station, and alleges that her boyfriend tried to forcibly remove her shirt in a dress shop, seeking legal action to be taken, but X refuses to take note of the incident and asked her to file a criminal complaint before a magistrate. Here, X committed a misconduct, but not any penal offense, cognizable offense, non cognizable offense, none of the above. आंसर भी वही है, क्वेश्चन भी वही है. Yes. Very good, everyone, guys. I am really happy that you guys are answering the question right. Such heavy questions, and you are, although very easy, but you are answering the question right. This is directly from Schedule 1, which mentions Section 166A as a cognizable offense, which is also mentioned here in the question. So come on, like just you need to see the question and use the common sense. उन्होंने schedule पूछा ही नहीं दिल्ली वालों ने. They just asked a very simple question. Can someone tell me what is 166A of CPC, of IPC? Write it in the comment box till the time I read the next question. Which of the following statements is or are true? Inquiry means every inquiry, including a trial conducted under the Code of Criminal Procedure by a magistrate or the court. Inquiry means every inquiry other than a trial conducted under the Code of Criminal Procedure by a magistrate or court. Investigation includes all the proceedings under the Criminal Procedure Code for the collection of evidence conducted by a magistrate. All of these. I'm asking which of the statement is true. Very good. स्टार्टिंग का पार्ट सबने अच्छे से पढ़ा है. आई कैन सी दैट. कंफ्यूज तुम लोग उधर हो ट्रायल्स में. Yes, this is a DJ's previous 2014 question, which is option number 2. Very good, guys. These will secure you good marks. Very good. Let's move ahead with the next question. 166A मुझे किसी ने नहीं बताया. Very poor. Next question is, in order to compel appearance of a person who is absconding in spite of a warrant of arrest being issued against him, his property may be ordered to be attached simultaneously with issuance of a proclamation under Section 82 of the Code of Criminal Procedure, provided that court is satisfied that such person is about to dispose of the whole or any part of his property, about to remove the whole or any part of the property from the local jurisdiction of the court, either one or two exist, both the condition has to have to coexist. देख लिया बेयर एक्ट रूना ने. Good. Yes, everyone is correct here. The correct answer is option number 3. 83 clause 1 is about the attachment of the property of person absconding, which is somewhere relating to issuance of proclamation. Let's move ahead with the next question. Then, which of the following is not an essential search procedure under Section 100 of the Code of Criminal Procedure? Calling upon two independent and respectable inhabitants of the locality to witness the search, signing of search memo by the witness to search, attendance of occupant of the place during the search, signature of the accused on the search list. Yes, this is option number 4. Very good, guys. But Maya, I asked 166A of IPC. CRPC nahi. IPC mein, I was asking the offense under section 166A. Yes. The first three options are covered by subsection 456 of section 100. So obviously that is correct option, which is option number 4. The next question is, no wife shall be entitled to recover maintenance from her husband under section 125 of the Criminal Procedure Code if she has obtained a divorce from her husband and has not remarried, is unable to maintain herself, refused to live with her husband on the ground that he keeps a mistress, is living in adultery. Very easy. Very good, Malika. This is very easy. Yes. Option number 4, 125 clause 4 is the relevant section here. Just see the importance of maintenance, guys. A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust or cheating. At trial, formal charge is framed only for the offense of theft. The evidence adduced at trial shows that he committed the offense of criminal breach of trust also. He may be convicted for the offense of theft only, for which formal charge was framed. For the offense of criminal breach of trust, though he was not charged with such offense, the trial is vitiated. None of these. Malika, come on. No. You cannot do this with this question. I'm expecting very high from you. This is very basic. All of you are answering very correct. Very good, Pritika, Shivani, Akash, Divya, George. Malika, I hope आपने previous question का answer दिया हो and I'm not seeing this. I just don't want to see this कि you answered option 1. This is option number 2 and very straight away mentioned under section 221 clause 2. Please read the whole charge chapter today, Malika. Please पूरा का पूरा charge पूरा का revise कर लो आज दोबारा. Section 164 of CRPC 1973 statutorily mandates that a judicial magistrate shall record statement. I hope ये mistype हुआ हो आपसे Malika. I'm not getting this out. Shall record statement of the person against whom offence has been committed under any section of the IPC. कोई बात नहीं, कोई बात नहीं. Just revise the whole chapter today. Under any section of IPC for all offences punishable with imprisonment in all the cases where the accused moves an application for the said purpose for cases punishable under section 376 of IPC. Yes, this is very easy. The correct answer is option number 4 here. See, section 164 mandates that a judicial magistrate should record the statement of few of the sections. Otherwise, the magistrate who has jurisdiction can record the confessions. For only the judicial magistrate can record the confession of few of the sections, out of which 376 is the correct answer. So, थोड़ा सा confusing था ये. Straight from the Bare Act, but a little tricky. The next question is, a valid proclamation under section 82 of the CRPC 1973 requires public reading of the proclamation in a conspicuous place of the town or village where the accused ordinarily resides. Copy of the proclamation should be affixed at some conspicuous place of the house in which the victim resides. If passed by a session judge, a copy of the proclamation should be affixed to some conspicuous part of the High Court. Copy of the proclamation is affixed on conspicuous part of all police stations in the town, village where the crime was committed. Very good. Very good, Malika. Very good, Kanika, Pritika. Yes, the correct answer is option number 1. Directly from section 82, which talks about proclamation for persons absconding. Very good. Which of the following persons is not entitled to maintenance under section, again maintenance, section 125, from a man who has sufficient means and refuses to maintain them? The man's wife, the man's illegitimate minor child, daughter-in-law, the man's father. Mostly a very common question in all the prelims exam. Yes, very good. Very good, Malika. Again, I'm giving extra 5 seconds. Why there's a difference of opinion? I hope, George, this is mistyped. This is daughter-in-law. Daughter-in-law does not get illegitimate child gets the maintenance. This is a DGS 2018 question. Who amongst the following is unable to maintain herself due to physical abnormality under section 125 CRPC? Illegitimate minor unmarried daughter, illegitimate major unmarried daughter, illegitimate minor married daughter, all of the above. Read this question थोड़ा ध्यान से. Yes. All of you are right. Correct answer is option number 2, 125 1 ka clause B and C, subclauses B and C provides who all are entitled to maintenance. A police officer may arrest somebody accused of an offense to prevent such person from committing any further offense, for proper investigation of the case, to prevent tampering of evidence, all of the above. Yes, correct, Malika. Major married daughter, correct. Everyone is right. Very good, Medha. Very good, Anikwa, Malika, Shrishti, Runa, Maya, Shivani, Singer. All of you are correct. Yes, it is option number 4. Section 41 is the relevant provision here. Under Section 68 CRPC, a person can be arrested in case of commission of offence in the presence of a police officer on credible information about commission of the offence, punishable with imprisonment for more than 7 years, on a complaint by a victim when a police officer has reasons to believe that the concerned person has committed the offence under all these circumstances. This is a slight confusing. I'll require all of you to mention what is section 60A also of CRPC. It is a two-line section. Yes, everyone is right. Option number 4 is the correct answer here. The relevant sections are different sections, one for like the different subclauses, and you need to gather all the options and mark under all these circumstances. I'm really happy that all of you are answering the questions right. Yes, correct. Correct, Malika. So the next question is, a boy aged about 14 years is suspected in the commission of the he can be made to join investigation at the police station, at his residence, at any place, or all of the above. Difference of opinion again. Pratika, read the question again. Very good. Everyone else, a very good observation. This is also a DJ's 2011 question. Very good, Medha, Anikwa, Runa, very good. Yes, only in his residence. Section 160 prescribes that no child or a woman child above below the age of 15 years shall be required to attend any place other than his or her residence. Next question is, the Supreme Court in the case of Lalitha Kumari held that while ensuring and protecting the rights of the accused and the complainant, a preliminary inquiry should be made in the time bound manner, and in any case, it should not exceed 7 days, 5 days, 10 days, 14 days. आता है तो आता है, नहीं आता है तो नहीं आता है. This is such a question. And this will give you one more point if you will be able to answer this. Very, very good, Malika. Very good. Yes, very good. Everyone else, very good. Yes, very good, George. It is 7 days and it was held in the very landmark case of Lalita Kumari. The preliminary inquiry, it is not mentioned. The time is not mentioned anywhere in the Bare Act of CRPC, but it was a landmark judgment and made a very landmark uh, time bound preliminary inquiry, which has to be finished in 7 days. The next question is, Garima ma'am is going to give you a gift, guys, if whoever answers correct most of the questions. So buck up, guys. Come on. Are we on the same page? या सब सो गए? Because I can see 27 people and only 10 to 12 people are answering. Rest of them are just seeing the questions. Yes, चलो लिखो नहीं कमेंट बॉक्स में, हार्ट ही दे दो. I can see the hearts. Yes, chalo. Let's move ahead with the next question. Recording of pre-summoning evidence may be dispensed with under Section 200 CRPC if the complaint is supported by the affidavit of the complainant, if the complaint is made in writing by a public servant in the discharge of his official duties, if the complainant is a senior citizen, all of the above. अनिक्वा, हर चीज का ऑल ऑफ द अबव नहीं होता है गाइस. प्लीज रीड दैट क्वेश्चन अगेन. 200 को दोबारा. यस, रियली रियली प्राउड ऑफ यू अरमान. Hi Arman, welcome to the comment box. I think you were there in the session but not active in the comment box. Please reply the correct answer. You recognize the correct answer very, very, very right. And Runa also, yes, the correct answer is option number 2. Section 200 prescribes that if the complaint is made in writing by a public servant in discharge of his official duties, then recording of pre-summoning evidence may be dispensed with. Okay, with regard to proceedings under section 125 CRPC, which of the following prepositions is correct? Strict proof of marriage is necessary. Standard proof is very high required in a proceeding, and thus Hindu marriage under Hindu Marriage Act 1955. Prima facie proof of showing that the parties are living as husband and wife is sufficient. Prima facie proof showing that the parties are living as husband and wife is not sufficient, and something more is required. Chalo, Shaktija is back now. Yes, the correct answer is option number 3. That is why wo wala question, the one I showed you where Shaktija replied that 125 is secular, did not mark the option correct is that the wife should be a legally wedded wife, because prima facie proof that the parties are living as husband and wife is sufficient to make a point under section 125. Yes, correct answer is option number 3. Everyone is answering correct now. Under section 260 CRPC, which of the following offences cannot be tried? Offence of theft where the value of the property does not exceed 2000 rupees. Offence punishable with imprisonment up till 1 year. Offences under 454 and 456 IPC. Offences punishable with imprisonment exceeding 2 years. मैंने बोला था पहले, I told you guys before also that remind me the question where I'll be asking you that which section is relating to. बोल दूंगी, पहले आंसर कर दो सब. Everyone is answering wrong. Summary trial. Guys, this is 260 is relating to summary trial. Now try to answer. The correct answer is yes. Now people have started answering correct. Very good. Sanyam, Divya, Kanika, very good. The correct answer is. Acha, you read the question incorrectly. No problem. The correct answer is option number 4, and this is the reason why you need to read the questions twice when you are giving the exam, and just mark the answers on your question paper and not on the OMR sheet directly, because this happens, especially with lengthier questions. So the next question is section 164 CRPC provides for recording of a confession or a statement in the course of investigation only, at any time after conclusion of investigation and before commencement of the trial, during investigation, or at any time or afterwards, before commencement of inquiry or trial, during investigation, inquiry or trial. This is very easy. थोड़ा सा कॉमन सेंस, अगर नहीं भी पता है तो थोड़ा सा कॉमन सेंस. Very, very good, Pritika. Very good. Oh, sorry, Shaktija. Very good. Yes, the correct answer is option number 3, during investigation or at any time afterwards before the commencement of inquiry or trial. Even if the investigation is completed but the inquiry and trial are not started, the confessions under section 164 can be recorded. Though it is a section under the chapter of investigation, the correct answer is here only option number 3. This is why option 1 and 3 were confusing, and why I am saying you this, because I remember that I made this mistake when I appeared for one of the exams. So this is confusing, but yes, option number 3 here is the correct answer. Very good, Runa. Very good, Shaktija. Okay, so the next question is under section 199 of CRPC, in a prosecution for defamation of Vice President of India, Sessions Court may take cognizance of such offence without the case being committed to it, but only upon a complaint in writing made by district magistrate, director general of police, public prosecutor, the president of India. Okay, this is a very straight away from the Bear Act, and the correct answer is option number three here. Yes, public prosecutor. You need to, like, under section 199, the complaint only has to be made in writing by public prosecutor. Orally, nahi, in writing by public prosecutor. Come on. I hope the codes are visible now. My frame is on the left side and the codes are visible, I think. Yes, it is. A police officer has the power to arrest any person without an order from a magistrate or warrant of arrest if he has a reason to suspect his complicity in a cognizable offense, punishable with imprisonment which may extend to 7 years, provided that he is satisfied for reasons in writing that such arrest is necessary to prevent such person from committing any further offense, for proper investigation of the offense, to prevent such person from tampering with or causing the evidence of the offense to disappear, to compel the absconding co-accused to surrender. Codes are given. Welcome Prakash in the comment box. Okay. Everyone is answering right. Yes, it is option number C, and this is a direct question from 41. To compel the absconding co-accused to surrender, this is nowhere mentioned, and all the above 3 points are mentioned under section 41. Next question is, when examined under section 313 of CRPC, a circumstance incriminating the accused is not put to the accused before his explanation. The said circumstance cannot be used against the accused because it is inadmissible in evidence. It becomes irrelevant for the purpose of evidence. Law mandates that it cannot be taken into consideration, or all of the above. Yes, it is option number C. Law mandates that it cannot be taken into consideration. It does not become irrelevant for the purpose of admissible evidence, or it is not inadmissible. But law mandates that it cannot be taken into consideration, which is also a part of Article 20. Okay. Section 315 of the CRPC, I asked this section before also, relates to the accused person as a competent witness. With regard to this, which among the following statements is not correct? An accused can be compelled to adduce evidence by the court of law without any application in writing by him. The failure of accused to give evidence shall neither be subject to any comment by parties or court, nor shall give rise to any presumption against himself or any other person facing charges along with him at the same trial. Any person accused of the offense before criminal court shall be a competent witness for the defense. A person accused of an offense may voluntarily give evidence on oath in disproof in of charges made against him or any person charged together with him at the same trial. Not correct. Very good. Very good. Everyone. Malika, Pritika, Kanika, Medha, Shivani. Very good, guys. Shaktija, read the question again. The not correct. It is, I'm asking you the not correct option. The accused has to make application in writing to be a competent witness under section 315, which is mentioned in the very first line of section 315. So, yes, it is option number one. Next question is, A faced trial for cheating Z by dishonestly inducing him to lend money by knowingly pledging him fake diamonds. Z died during trial and was served by his son X. X moved an application in the trial court to compound the offense. Which of the following is the correct legal preposition? X is not competent to compound the offense. On the death of complainant Z, the trial proceeding shall abate. Court cannot entertain such an application after the death of the complainant. X can compound offense with the consent of the court. Yes, George is right. The correct answer is yes. Shrishti correct. Pritika correct. Kanika correct. Malika correct. Yes. The correct answer is X can compound offense only with the consent of the court, because such an offense, the offense of cheating is compoundable with the permission of the court, but not without the permission of the court. So that is why A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust or cheating. At the trial, formal charge is framed only for the offense of theft. The evidence adduced at trial shows that he committed the offense of criminal breach of trust. He may be convicted for the offense of theft only, for which formal charge was framed. For the offense of criminal breach of trust, though he was not charged with such an offense, the trial is vitiated. None of these. Come on, Malika. किस्मत ने रिपीट किया है ये मलिका के लिए क्वेश्चन. Yes, this is B. Okay, this was repeated. Yeah, the slides got mixed. Okay, and the next question is, in which of the following trials under the Code of Criminal Procedure hearing of the accused on sentence is not necessary? Sessions trial, trial of a warrant case, trial of a summons case, and all of the above. Hearing of the accused on sentence is not necessary. This is very easy. Yes, this is summons case. Summons case may the charges are not even like it is not necessary to frame the charges, and hearing of the accused is also not necessary. The bond executed for keeping peace on conviction shall be void if the conviction is set aside, the accused is absconded, the order is made by the appellate court, any of the above. थोड़ा सा ट्रिकी है ये. Guys, every question's answer is not always all of the above. Very good. Really impressed. Yes, the correct answer is option number 1 here. It is under section 106, clause 4. Obviously, when the section is itself about keeping peace on conviction, then the bond obviously is void only if the conviction is set aside. So that is where you get confused, and the correct answer is option number A. Some of you have answered option number 4. Please read these kinds of questions twice because these become trickier one. ये मैं पूछने वाली थी पहले जब भी प्ली बार्गेनिंग के क्वेश्चंस आए, बट आई रिमेंबर दैट दिस इज द क्वेश्चन इन द upcoming slides. That is why I did not ask it. Plea bargaining is added to the CRPC by 2005 Amendment, Act number 25 of 2005, Act number 2 of 2006. Is it by Amendment Act of 2006 or by 2003? Okay. Direct Bear Act question. Yes, it is option number B. The Act is of 2005, but Act number is of second Act number of 2006. So remember this, that you have to read the Bear Act from cover to cover. Which of the following acts does not relate to offences affecting the socio-economic condition of the country as notified under subsection 2 of section 265A of Code of Criminal Procedure? The Explosives Act 1884, the Immoral Traffic Prevention Act 1956, the Arms Act 1959, the Cinematographic Act 1952. Come on, guys. This is also a Bear Act centric question, but you guys can also apply your mind here. Eliminate कर दो 3 options को. The common acts. C is the correct answer here, guys, not D. Please read the list mentioned under section 265A subsection 2. Arms Act में plea bargaining क्यों करेंगे हम? We can never do plea bargaining in Arms Act. This is very obvious. Such a grievous act, and we cannot do. Cinematographic Act, Immoral Traffic Prevention Act is also very grievous, but comparatively, Arms Act is not mentioned. Plea bargaining is allowed in Explosive Act and Immoral Traffic Prevention Act. Okay, let's move ahead. Save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances to arrest exist, the woman police officer shall obtain the previous permission of the following: district magistrate, superintendent of police, judicial magistrate of the first class. Again, a bare act centric question. That is why I'm not giving you any extra time here. Why A? Only Pritika was able to, Prakash, Pritika, Kanika were able to answer it correctly. It is judicial magistrate of the first class. 46 clause 4 mentions it. Okay. Let's move ahead with the next question. Which of the following is not an act of the for the prevention of which an order cannot be made under section 144 CRPC? Annoyance to any person lawfully employed, injury to any person lawfully employed, disturbance of public tranquility, none of the above. Not an act. Not an act. It is option number 4, none of the above. Since it was asked not an act, all the three conditions are mentioned under section 144. I think subclause 1 it is, and it is mentioned, yeah, subclause 1 it is. It is mentioned there that all the three conditions, the order can be made under 144. So this is a trickier one because I asked not an act and none of the above is the correct answer here. Next is whether in a summons trial case instituted otherwise than on a complaint, a magistrate of the first class can stop the proceedings and discharge, not acquit the accused without pronouncing judgment. No magistrate must, after recording entire evidence, pronounce final judgment of conviction or acquittal. Yes, after evidence of principal witnesses had been recorded. Yes, was reason to be recorded where evidence of principal witnesses has not been recorded. Yes, as magistrate has discretion to discharge or acquit regardless of the stage of the proceedings. Summons trial. No. The correct answer is option number 3 here. Guys, read the summons trial, warrants trial, all the trials, all the 4 trials today after this session. The correct answer is option number 3, section 258. C, yes, Tamanna. It was a DJS 2018 question. Where the evidence of a principal witness is not recorded, the court can discharge and not acquit. I hope the difference between discharge and the acquittal is clear. The court does not have power to acquit in any of the cases without, hearing or pronouncing judgment. So they can discharge only in summons cases. So it is mentioned under 258. Okay. Which previous question? No, this is injury only, George. This is injury only. Section 144. Please read the section carefully. I have the Bear Act open next to me. I've read the question twice and thrice and then made the PPTs. It is injury only. Okay. Next question is, in the case of an accused facing inquiry of trial, though not of unsound mind but not capable of understanding the proceedings, the court shall proceed with the inquiry or trial. The court shall not proceed with the inquiry or trial. The court may proceed with the inquiry or trial after obtaining necessary orders from the High Court. The court may proceed with the inquiry or trial, and in the case the same results in conviction, forward the proceeding to the High Court along with the report on which High Court shall pass such orders as deemed fit. Yes, that was injury only, not inquiry. Correct. Very easy question directly from the Bear Act, but a lengthier one. That whenever the question is text heavy and it is taking all your screen or all your length of your paper, please do not get afraid. Those questions are the easiest ones. No. Only one person has correctly answered. Two, three. Yes, correct. Correct answer is option number four here. 318 is the relevant section directly taken from the Bear Act. The procedure is that if it results in the conviction, then the High Court, the same has to be forwarded to the High Court, and the High Court will pass the order in case of the persons who are not unsound but cannot understand the proceedings. In a summons case, at the time of appearance of the accused before the magistrate, it is unnecessary to. I have mentioned this galti se pehle, so please mark this question right. I am hoping everyone to answer this correct. State the particulars of the offense of which he is accused, frame a formal charge, ask him whether he pleads guilty, ask him whether he has any defense to make. Unnecessary to, not required in a summons case. ये मैंने बता दिया था तुम लोगों को. Very good. Yes. The correct answer is option number two. 251 is the relevant answer is here. Read all the four trials after this session, guys. Section 315 CRPC, an accused be a witness. An accused can be compelled to give his own evidence generally. An accused can be called as a witness only on his own request in writing, either one or two. Shaktija, come on. This is your question now. Yes, the correct answer is option number three. Only on his own request. Shaktija, please read section 315 again after this session. Option number three, only on his own writing. Next question. Section 311 of CRPC, a witness can be called on the motion of the prosecution, on the motion of the defense, on its own motion by the court, all of these. 311. Yes, the correct answer is option number four. Very good, George Komal. Power to summon material witnesses or examine the person present. The motion of the prosecution, nothing mentioned as such. So this is actually an interpretation based question that the witness, the material witness, the examination of the person present can be done on the motion of the prosecution also, defense also, and on the motion of the court also. Next is A is suspected of commission of an offense of murder, trial whereof can only be conducted before a court of sessions. A appears before Metropolitan Magistrate and moves an application for recording his statement under 164 CRPC and grant of pardon. Who has the power to grant pardon? The Court of Sessions, the Metropolitan Magistrate, both A and B, none of the above. This is a DJ's deserving question. Nobody is answered correctly. Guys, this is only the Metropolitan Magistrate. If you'll read section 164, if you'll read section granting of pardon, which is, I think, section 306, yes, it is 306 only. 306 mentions the stages where Metropolitan Magistrate can grant the pardon. This is a DJ's deserving question. I told in the beginning also, because this is all happening in the stage of investigation. Statement under 164 CRPC. The person is moving an application for recording the statement under section 164 CRPC, and trial has not commenced yet. So 164 is before the stage of inquiry and trial and during the stage of investigation. That is why the Metropolitan Magistrate can only grant the pardon. Yes. So this was a really brainstorming question. Read the granting of pardon provisions after this session again. What is not true? Magistrate may discharge the accused if complainant is absent on the date of hearing. If offense is Compoundable, non-cognizable before charge has been framed. Provision would be applicable for complaint case and police cases both. Come on, guys. The correct answer is option number 4. Yes, very good, George. Provision would be applicable for complaint case and police cases both, and this is mentioned under 249 very straight away. And the question was not true, so you guys are in sync now. Next question is: a minor girl lived with her father at Delhi. She became intimate with the accused and ran away with the accused from Delhi to Dehradun in a taxi. After some time, they eventually settled in Mumbai. An offense of kidnapping may be tried at Delhi, at Dehradun, at Mumbai, at any place mentioned. I think this is the last question for the day. We have done 100 questions, guys. Very true. Very good, Malika. Very good, Kanika. Shaktija, please read the charges wala section again. Pura ka pura chapter again. Runa, very good. Tamanna, very good. Kritika, very good. Maya, very good. Yes. Section 181, clause 2 says that whenever there is an offense of kidnapping, and though such an offense where conveyance is involved, the offense can be tried at any of the locations where the person, the victim, is conveyed. So this is okay. One more question. Any public prosecutor or assistant public prosecutor in charge of a case may, before the judgment is pronounced, withdraw the prosecution of any person. For this, he has to take consent of central government, state government, court, all of these. Very good. It is very straight away mentioned under 321 that he has to take the consent of court. No administration authorities are involved here. Only the judiciary is involved under section 321. Next question: the Code of Criminal Procedure 1973 can be amended by Parliament or any state legislature. The Parliament only, the Supreme Court and the Parliament, state legislature only. Come on, guys, last few questions. Yes. Very good, Anikwa, Runa, Lohat. Welcome to the comment box, Lohat. Komal, Medha, Shaktija. Very good, everyone. Yes, exactly. This is the part of the concurrent list. That is why it can be amended by the parliament or the state legislature. Very good, Shaktija. But read the charge wala chapter again, pura ka pura, and wo 315. An inquest report must contain the names of the accused, the apparent cause of death, the details of weapons, the details of incident. इंक्वेस्ट रिपोर्ट का सेक्शन तो बता दो जरा कमेंट पे सब एक बार प्लीज मेंशन द सेक्शन ऑफ report in the comment box, everyone, now, before answering the question. I need everyone to tell the section first. I hope you guys could have unmuted yourself and told me inquest report को हिंदी में क्या बोलते हैं. Yes, the correct answer is the apparent cause of the death, and the relevant section is 174. Really, really, really awesomely performing. You guys are on fire today when it comes to the direct questions. At trial, it appears to the magistrate that the case ought to be tried by the Court of Sessions. In which section of the court he shall commit the case? 209, 323, 325, none of these. Again, a direct question. Panchanama, yes, correct, Shaktija. Which section is about committal of the case to the Court of Session? Yes, it is option number 2. 325 is the making over of the case, and 323 is the committal. If person identifying the person arrested is mentally on and physically disabled, who will supervise the process of identification under CRPC? Any executive magistrate, any judicial magistrate, district magistrate, chief judicial magistrate. Mayor committal under 209, yes. Okay, difference of opinion here. Pritika, right? It is under section 54A that judicial magistrate is the person who will supervise it, and it was added after 2013 amendment. So this was all for today, guys. We have done 100 questions. How are you feeling? Was it good enough? Are you guys थोड़ा सा brainstormed? CRPC अंदर तक आ गया है आप लोगों के अभी? You're welcome. You're welcome. Okay. So let's meet again tomorrow with the second part of CRPC, which is yes, ma'am, maza aa gaya. Okay, thank you, Malika. Let's meet again tomorrow. Guys, I also really enjoyed interacting with you all. Fruitful session. Thank you, Pritika. You are on fire. Aniko also. George, I'm really proud of you. Malika, Shaktija, Komal, everyone performed really well. Let's see you guys tomorrow with the second part of CRPC. I hope the preparation is on